Good morning, everyone. We are delighted to see you all at today's seminar titled Arbitration in the Islamic Economy, Developments and Challenges, organized by the International Islamic Center for Reconciliation and Arbitration, also known as IICRA. I am Vanessa, your host for today. To start the event on a good note, let us hear a welcome speech from the General Secretary of IICRA, Dr. Rami Sulaiman.
Assalamu alaikum wa rahmatullahi wa barakatuh. The International Islamic Center for Reconciliation and Arbitration welcomes you all on this event. I would like to express my appreciation to all distinguished attendees and speakers who has joined us today. Thank you for being a part of this seminar. Ladies and gentlemen, as you all aware, IICRA's main objective is to resolve all kinds of financial and dispute through the institutional reconciliation and arbitration. Is in compliance with Sharia provisions. Rest assured that the arbitrary award issued by IICRA are Sharia compliant. In fact, IICRA plays an important role as an infrastructure institution of Islamic financial industry, whose value as assets exceeded $4 trillion according to the recent statistic. Further, IICRA is dedicated to achieve several benefits in dispute resolution services, which are as follows. First, IICRA focuses on adopting reconciliation as a preferred method, as the Holy Quran was Sulhu Khair, the reconciliation is better. Second, IICRA ensures specialization in resolving disputes through the extensive arbitrator, which is rostered of over 400 registered arbitrators who are well-versed in all kinds of Islamic financial transactions. Along with the IICRA Supervisory Committee oversees as the Sharia and compliance with the thorough review the legal and Sharia perspectives. The updated statistics suggest that the average period of arbitration in IICRA approximately 4 months. This commitment go hand in hand with applying principles of justice and ensuring that all parties have ample and equal opportunity to present their arguments and pleadings. IICRA's procedures are designed to safeguard the privacy of information and documents related to the arbitration cases, ensuring that the reputation and the financial standing of the parties remain protected from any damages due to the claim. Arbitral award issued under IICRA are final and binding, as they conform to the International Arbitration Award standards and include legal and Sharia perspective and reasoning, and have already been enforced in many jurisdictions. IICRA arbitrators and experts should adhere to Code of Ethics of IICRA, as per the IICRA rules. IICRA has a unique e-platform for arbitration and reconciliation aimed to reduce the expenses and ensure the flexibility and efficiency of dispute resolution. IICRA is dedicated to cost-efficient dispute resolution with our administration fees set as a maximum 2% of the total value of the claim since IICRA operates as a global non-profit organization. All these advantages has contributed to the growing demand of IICRA services. As shown in this chart, a straightforward here comparison with the number of IICRA and other international arbitration centers highlighted the expanding influence of Islamic arbitration. This aligned with the development growth observed in Islamic financial industry today. Dear participants, IICRA is also committed to promote the culture of arbitration by different tools such as first, by advising by the training program of SIA arbitration training program. This is comprehensive program cover the legal and Sharia and technical aspects of Islamic financial transaction. It is also focusing on the skills required of the arbitrator. Notably, over 400 participants and attendees have already completed SIA arbitration training, which is available in 3 languages, Arabic, English, and French. Second, by holding events such as this one and our upcoming international conference on Islamic financial transaction between legislation and the practice, scheduled for December 21, 22, 2023 in Dubai. And I would like to take this opportunity to extend an invitation to you to attend this seminar. At the end, I would like to extend my heartfelt appreciation for your attendance. I hope that you will find it productive and in terms of the knowledge shared and meaningful discussion and the opportunity for networking and constructive connection. Thanks so much.
Thank you very much, Dr. Rami Sulaiman, for the warm welcoming remarks. Our first session on practice of arbitration in Islamic economy will be moderated by Dr. Suzanne Munir Abdullah, an arbitrator and partner at OGH Legal. She has 17 years of experience working in the Middle East and acts as counsel in a broad range of complex and international disputes in various sectors. She was appointed as a sole arbitrator and co-arbitrator with IICRA in several disputes related to Islamic finance. Further, Dr. Abdullah is a lecturer at St. Joseph University and teaches civil law, e-commerce law, labor law, innovation and entrepreneurship, and intellectual property law. The topics for our first session are, first, main features of IICRA arbitration rules, and second, arbitral awards under IICRA arbitration rules. Let us get to know our esteemed speakers for the first session, to be introduced by Dr. Suzanne Abdullah.
Thank you, Vanessa, for this introduction. Thank you, Dr. Rami, for giving us the opportunity to be here in this session. As you know, today the topic is hot on arbitration. It's about application of arbitration in Islamic economy. For this reason, we have invited our speakers to effectively navigate and discuss how we can manage arbitration proceeding before IICRA and under IICRA rules. I would like to welcome and introduce our speakers, Mr. Ahmed Ibrahim and Dr. Kamal Malas. Mr. Ahmad is a full-time independent arbitrator. He is a member of the advisory committee of Dubai International Arbitration Center and a member of the advisory committee of the Cairo Regional Center for International Commercial Arbitration. He is recognized by Who's Who Arbitration as a global leader and by Legal as an excellent practitioner. He is featured by Chamber and Partner as one of the most in-demand arbitrators in the UAE. Mr. Ahmad is also a member of the Egyptian Commission to the International Chamber of Commerce. He is shortlisted for the GAR prestigious award of Most Responsive and Prepared Arbitrator. Dr. Kamal Mals is an engineer and holds a law degree and PhD in law. He's listed engineer as an engineering expert with Dubai Court and UAE Ministry of Justice. He's an international arbitrator that handles cases related to engineering and construction, real estate, media, insurance, and maritime in UAE, Qatar, Oman, Kingdom of Saudi Arabia, and UK. He is a mediator as well. He friendly reviewed the 2017 FEDECIRO book. He's the head of arbitration and legal affairs at Arab Union for Investment and Real Estate and member of the ICC MENA Region Arab Arbitrator Group member. Dr. Malas handled more than 100 arbitration cases in different arbitration centers, such as IICRA, ICC, DIFC, LCIA, and UAE Court, Abu Dhabi Arbitration Center, DIAC, LMAA, and many other international arbitration centers. In addition, he was appointed as arbitrator in many ad hoc arbitrations in the GCC and UK. In today's session, we have no intention to take you through detailed IICRA rules, which are composed of 65 articles for arbitration and 18 articles for conciliation, in addition to appendix and exhibits. However, our main intention is to highlight or give a summary about unique feature of IICRA rules if we compare to other arbitration centers. I will start with Dr. Kamal. Dr. Kamal, being a registered arbitrator with IICRA, and you handle many cases under IICRA rules, can you give us your perspective in relation to what's the key feature of IICRA rules?
Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Wassalatu wassalamu ala Sayyidina Muhammad sallallahu alaihi wasallam. Thank you, Dr. Rami, for inviting me and for holding this event. And also thanks for all of the audience who are professionals. I've worked with some of them in arbitration cases before. And it is a privilege and an honor to be here to speak about IICRA rules before this distinguished audience. Also, thank you, Dr. Susan, for the nice introduction. And in replying to your question, Dr. Susan, I see that a lot to talk about. But as you said, we have a limited time, so we will only highlight some. We will not go deep. Reality, I have checked the rules before I start working with IICRA, and I found that there are advantages and some also. We talk now about key advantages, not all of the advantages, because the time is not allowing us. I will start with the rules in general. The rules are including the new visions in the international operations. So when you hear Islamic, you don't think that it is limited to some Islamic rules or Sharia rules. It is wide and new and has the visions of the new rules that are adopted in the industry in the world. So this is one. I have seen something which is interesting to me in the notifications inside these rules. Notifications inside these rules are helping the arbitrator, the parties, and the center to notify the other party. I have been working on many cases in other arbitration centers, and we were facing a problem of notification. How to notify a party who closed his offices and he is outside the country. Now, if the arbitrator finalized the award, the procedure, everything is correct, this award will be nullified because of notification or not. And this is a procedure issue. The award could be notified because of this. Yeah. when you read the notification under the IICRA rules, you will be astonished. A place of business, physically delivered to the address, his habitual residence, mailing addresses by register letter, courier companies, fax, any address known. And you can see, I was looking, is there a pigeon or zajir inside? That, they did not left anything. They closed all of the doors. That notification will be correct under the rules. So this is a very important, crucial issue. Solve the problem which we face. I've made many meetings in the national centers about the notification, and I see it is so in very solid way in these rules. Now, I will move to another key advantage, which is the speedy timetable. When you file the case in the IICRA, you will see that the center is motivating you to be speedy. Why? They took the request 2 days, 5 days, 3 days. There is no 30 days, there is no 60 days. It is very fast. So you feel that you are, there is a reply here. So as a party, it is active, and the reaction of the center is very speedy. It is in the rule. So it is not a private work. It is in the rule. So from the beginning, you must be ready to work as an arbitrator in this center. You cannot sleep. You can day and night. You find yourself working. Also, as the Islamic Sharia, as Dr. Rami said now, the best judgment is the judgment which are based on the amicable settlement. And you can smell from the rules, and it is high smell, that they are aiming, and the goal is to work amicable. The environment of the rules and the center and the people who are working there, they are looking for amicable settlement more than arbitration, because this is the interest of the party. You know, all of you are professionals, and you know that the aim of the arbitration is to keep the relationship between the parties. So if I reach amicable settlement, it's better. And you see that the Article 31 of the rules requesting the tribunal to request the parties, do you have the desire to make to trigger the amicable settlement negotiation? If they express yes, then also Article 31 empower the tribunal to suspend the case for maximum 30 days, enabling the parties to reach to an amicable settlement. So it is inside the rules. We see this is the environment of the amicable settlement. Also, the low cost. We see that as Dr. Ryan has mentioned, that it is non-profitable center, and they try to keep the loss to less than the 2% of the claimed amount. So they have a cap. They did not let it open. So there is a cap, and that is for the benefit of the parties. Maybe the arbitrators say something about that, but it is, I think, even for the benefit of the arbitrator. He will finish this case and have another one. Okay? So try to make it speed. Also, there are free facilities provided by the center. For example, I see besides the logistic and administrative support throughout the process, the center is providing a free arbitration hearing room. So the parties and the arbitrator can use the hearing room of the center free of charge, because they are registered their case, whether it is small or big. They pay small fees or high fees. This is their right to use this room. It is not related to the amount of the claim. It is related that you have registered your case here. This facility is free for you. So this is loading the rules. Also, I think I will not go deeper, and I will leave the mic to Dr. Suzanne if she has any comment here. Thank you.
Thank you, Dr. Kamal. Ahmed, as you have seen, Dr. Kamal has highlighted on important key features on the IICRA rules. But one important feature that's really unique for IICRA that attracted my attention that the rule explicitly mentioned that you can arbitrate not only on contractual issues, but also on issues related to tort, which is really unique. I don't know, I cannot remember like in any other arbitration center where we have seen something like this, where the rule refers or take into account to arbitrate on issues related to tort. From being an international arbitrator and have lots of expertise in local arbitration as well here in UAE, what do you think about this feature? Did you ever come across something like this?
Thank you very much, Suzanne, and thanks everyone. Good morning. I'm pleased to be here today, and I'm not sure if you hear me well, because sometimes I have a problem with the distance between the microphone and my mouth. People complain about the quality of the sound, say, put it closer, far. So tell me if you have any issue with that. I'm here today, obviously wearing different hats, being part of IICRA and DIAC and the ICC. So and acting as arbitrator as well in different jurisdictions and different seats of arbitration. And it's very interesting what I have heard from Dr. Kamal Malas and also from Dr. Suzanne regarding the reference to contract and tort in the rules of IICRA. I will start with your question. I didn't see this before in any other set of rules. I didn't see reference to the type of liability or the grounds of liability, because the starting point, in my view, that arbitration is, as you know, consensual by nature. So it requires a contract. There must be a contract at the very beginning before we arbitrate. And because there must be an arbitration agreement, and this arbitration agreement is a contractual arrangement or contractual instrument by definition. So the presumption here is any claims, or most likely any claims, will be based on contractual liability, but this doesn't prevent parties to raise claims under tort, of course. And we see this is a big difference between common law and civil law jurisdictions in this regard. While in common law jurisdictions, you can combine contractual liability and tort liability in one claim, and in civil law, correct me if I'm wrong, in civil law jurisdictions, you cannot. You have to choose one of the causes of action from the very beginning. But you can also claim another source of obligation, like unjust enrichment, for instance. Although the line of authority is by the Court of Cassation that in contractual liability you cannot claim unjust enrichment. But I mean, referring to the grounds of liability in the rules, or in the arbitration rules or the institutional rules, is something very unique. I didn't see before. I think the benefit of this one, if I put it this way, perhaps one of the parties will argue that this is a contractual claim and you have no ground to pursue claim in tort. So then, from a procedural point of view, purely procedural point of view, because the arbitration institutional rules are related to the administration of the arbitration from a procedural point of view, not substantive point of view. So at the end of the day, the decision as to allow the claim in tort or contract will be tribunal's decision. I will run through very quickly some of the aspects and features highlighted by Dr. Kamal Maras. He spoke about notification. Yes, of course, I agree with him. Notifications of arbitration, request for arbitration, as well as the award. Having a proper notification is a key issue, key aspect in any successful arbitration to ensure that your award is enforceable. I'm glad that the IICRA rules are following the international standards in this regard. Referring to all means of communications is is also adopted by the ICC, ATCAC, DIAC, and KERSICA, and SIAC, you name it. I think that's this is a reflection of how ICRA rules are progressive and following the international standards in this regard. The speedy timetable, or what I will describe as similar to fast-track arbitrations, I think this comes with some advantages, but in my view, it's not always suitable for all claims. In some cases, they are complicated enough, and the size of this dispute, the scale of dispute, the complexity of the issues in dispute would require you to have a bigger timetable, longer timetable. So to encourage the parties to proceed in a cost-effective and expeditious manner is something that is useful, but I think arbitrators should use that thing wisely according to the nature of the claim they are dealing with. And if I will compare this with other institutions do not impose any timetabling guidance on arbitrators. They say, please proceed in a cost-effective and expeditious manner. There is a policy, for instance, in the ICC, from the last submission, on the last substantive submissions, the sole arbitrator should deliver a draft of the award within 1 month. And if it's a 3-member tribunal, the timeline is 3 months from the last substantive submissions. Otherwise, the court can decrease the fees of the arbitrators as a kind of, motivating them, or incentive not to be late. Let's put it this way instead of saying penalizing. I see the low cost benefit is an important one. I think arbitration nowadays is the expensive justice. It's and to have a product that's especially providing high quality service and competent arbitrators and good service from the center at low cost, that's amazing. As well as the free facilities by the center. I find this very unique in the UAE, perhaps in ATCAC they do it, I'm not sure. But in Cairo we do it, by the way, but it's not common. It's not common in international institutions. These are my remarks about the special features, and yeah, but in general I see that there are very progressive rules, and they are full of advantages in my view.
In addition to what has been mentioned from Dr. Kamal, one can see the interplay between the arbitration proceeding and the court. Probably we can say we usually see in the local law of the seats as opposed to arbitration rules. The rule itself clearly mentioned it gives the tribunal how to conduct themselves. For example, when there is a challenge on their jurisdiction, and gives them the option, but not the obligation, even to stay the arbitration proceeding until pending determination of their jurisdiction. Another feature, Ahmed, is related to emergency arbitrator. We have been attending this week lots of events, and this was a hot topic even during the event. The rule deal with his role. It set a very specific timeline for his appointment, and even for the emergency arbitrator to decide on the emergency measures. Sometimes somebody, like if you look at it, you may see this is very intrusive from the rules, from the IICRA rules. However, we all know how much we need when there is an emergency arbitrator appointed to be appointed in a few days. And the rule indeed, it like mentioned and specify, that the emergency arbitrator does what the parties need and like even give a decision within a very specific time, which is, I think both of them, both you see these pictures.
What is the timeline for the arbitrator?
It's like
7 days.
Sorry?
7 days.
7 days, yeah. So either the way of appointing him 3 days, stuff like it's very short and limited time for him to be appointed. From your view, what do you think about these features?
Yeah, that's very helpful. One, and that goes in line also, it's consistent with the new trends in international arbitration now. All the international rules are encouraging having set of rules to deal with emergency arbitrator appointment. And the idea behind the emergency arbitrator, imagine you have a case, you need to take an interim measure, and the arbitration tribunal is not yet constituted. So you need something very fast. You need to stop calling a bond, for instance, instead of waiting until the constitution of the tribunal is made, which might take a long time sometimes, given the time limits. You ask the arbitration institution to appoint an emergency, and this must be before the appointment of the arbitration tribunal, because if the tribunal is already in place, you can put any application for interim measures to the tribunal. But before the constitution, you have no one, so you go to the arbitration center and ask for an emergency arbitrator. Emergency arbitrators, usually international rules, I will take the IICRA as a reference. They appoint the emergency arbitrator in 1 day. And if there is any, by the way, they called me before, and it was on a weekend, and I'll tell you this, I was fishing. I was fishing in the middle on a boat, holding my fishing rod with one hand and my mobile with the other hand, and the other people called me, Ahmed, we have an application for interim measure for you, you have to take it. I was like, okay, I'll check it now. Is it urgent? They said, yes, you have to take an action today. This is how it worked. And I think this is a very helpful feature, and it's good to have it in IICRA as well. But if I will comment about the time limit to issue the decision, I would say the IICRA, as well as the ICC, as well as the new IICRA rules, which will be launched today, by the way, say as soon as practical, and give the arbitrator a space of flexibility. They encourage arbitrators, okay, take a decision, take an action, hold a hearing if needed, call the parties, have a phone call, do everything to issue an interim measure as soon as possible, but without having a time limit. I assume in IICRA rules the time limit can be extendable in certain circumstances. Yeah, that's perfect in this case, because you never tell, you never know what the application is about. Arbitrators might need to see something or to visit the site, for instance, so they need to organize this in advance. The first one you mentioned is the suspension in case of challenging the jurisdiction of. Do you mean challenging the jurisdiction or challenging the appointment of the arbitrators? I assume, because challenging jurisdiction will require the arbitrators to decide the jurisdiction, so they cannot suspend. I think if there is a challenge on the appointment, and here there was a development in the position under UAE law in the past. Filing a challenge against the appointment of arbitrators resulted in the suspension of the proceedings by default. This was in the past. And this was very, very unhelpful, because it gave obstructive parties an golden opportunity to make challenges all the time, to delay. It's one of the delay tactics tools that parties used unduly. until I don't remember in which year, but at some point the Dubai Court of Cassation dealt with this specific issue and stated in a ruling that this challenge against the appointment of the arbitrator should not suspend the proceedings. The position in all international institutional rules is that challenging the appointment of the arbitrator should not suspend the proceedings. But of course, it goes without saying, if the arbitrators find that it is suitable to suspend, they can do that. No one. But having it in the rule is something I think it's at least you make sure that no one will argue about it. Okay, I have the power. I can suspend. I cannot suspend. That's the benefit of it. As well as, you know, I forgot to comment on encouraging amicable settlement. Did I? Okay. Invitation to settle is something that also a very helpful tool. But it's not found in any arbitration institute. I didn't see it in any arbitration institutions, I think. But I also found it very helpful.
Thank you, Adika. Dr. Kamal, how does the IICRA rules guarantee the alignment of the arbitration award with the provision of Islamic Sharia? Probably we need to elaborate on Article 35 and 54 of the rules.
Thank you, Dr. Sudan. In fact, the Article 35 and the Article 54 are talking about this. So Article 20 talk about. Yes, I want to give you the main approach here in the center is not to contradict the Holy Quran and not to contradict the Hadith Sharif of Sayyidina Muhammad sallallahu alaihi wasallam, Prophet Muhammad, peace be upon him. This is the main goal. So if the parties, for example, in Article 35, let's talk about Article 35. If the arbiter and the party shall determine the legal provisions applicable to the merit of the dispute based on what has been stipulated in Holy Quran and Sunnah of Prophet Muhammad sallallahu alaihi wasallam. Now, without prejudice to this article, if the legal provisions that they have agreed are not suitable, they can go to the viewpoints of various scholars of Islamic thoughts, or they can follow among mainstream scholars, or they can report to the Sharia standard issued by the Accounting and Auditing Organization for Islamic Financial Institution, which is I4, AAI, OFI, or according to the rulings of Islamic Fiqh Academy. So, but in all of these, if there is any provision for contradicting with the Holy Quran and Hadith Sharif, will not be alright. Okay, what the arbitral tribunal do if they found that there are law provisions, the party said they want to apply it, and these provisions are against Holy Quran or Hadith. Now here it is the role of the arbitrators themselves, when they must be familiar with the Sharia. I'm not talking they are scholars, no, but to have an idea, and we will talk about forming tribunal of 3 persons, how they will be familiar with this. But in any case, the tribunal will try to see and find the closest provisions which are closest to the justice and apply it. They will not apply anything against the Sharia rules. Also, they will try to find the more appropriate and relevant to the arbitration. So it is now between the hands of the arbitral tribunal. Also, they are applied in the matter not contradicting the Holy Quran and the Sunnah of Prophet Muhammad sallallahu alaihi wasallam. So now we see that even if the parties agree on certain provisions will not be applied if it is against Sharia. And it is the tribunal role and expertise and professionality how to choose the closest provisions to the interest of the parties and the justice how they apply. We see this is here related to Sharia, and in some previous arbitration cases we see there are famous cases where the arbitrator actually applied this mechanism by choosing suitable law. Here we are using the suitable provisions. So it is the principle, in a way it is international because you find the suitable law, and here you find the suitable provisions to apply the provisions which are not contradicting the Sharia. Then the Article 35 IICRA rules. And now I will talk about Article 54. Article 54, in fact, it is the supervision on draft final arbitral awards. The arbitral tribunal make the drafting of the award and send it to the center. The center has the right to send to check this, not from a merit point of view, of course. They can refer it to the supervisory committee, which is a higher advisory committee in the IICRA Center, to check whether this award is having any contradiction with Sharia or not. Also, the tribunal has the power to send the draft to the higher advisory committee to request their opinion about the Sharia in the award. So as I've said in the beginning, that the tribunal members are not scholars, and they are not required to be scholars, and they can, the award will be sent to the higher IICRA higher advisory committee. The higher advisory committee has 10 days only, we go back to the speedy, 10 days only to check this award and give a report which including the opinion. This opinion is not mandatory on the tribunal. You see here that we go to the tribunal. We go back to the tribunal. It is not mandatory, but they are good and good guidance and answer to their, if they have in mind some doubt about something, they give them the guidance. So they are not mandatory, but the tribunal will benefit from these comments, something they will add it to their explanations, because if the tribunal chooses to apply some provisions of law, they are required to mention in the award why they recourse to these provisions, why they apply this. They must put the reasons. So if these reasons are not sufficient or not enough, and they are right, but there are something to be elaborated more on this, they will take the guidance of the advisory committee with their expertise in Sharia, and they will tell them that it's better to mention this in the Holy Quran, to mention this in the Sunnah, to mention this, to mention that. They will enrich the award to be a complete award, could not be criticized that it is not according to Sharia rules. I think those are the elaboration of the two articles.
I think I can add even more from our experience with the tribunal. Usually when it's a sole arbitrator, he should be specialized in Sharia and legal at the same time. But when it's a tribunal, and sometimes it's most of the cases that we have seen, one of the arbitrator should be legal, specialized as a legal. One, for example, if the case is related to sukuk matters, another arbitrator should know the technical of sukuk, how they are published, procedure, and all of that. And the third arbitrator should have like expertise, Sharia perspective. He can understand the sukuk from Sharia perspective. So this mixture of arbitrator and specialization avoid that at a certain level the tribunal might need to appoint expert, as the case might be in other, for example, arbitration cases. So as far as what we have worked under the IICRA rules or in some arbitration cases with IICRA, we have never had the need to appoint expert because the arbitrator itself, we have always one specialized in Sharia and one specialized in the technical aspect of the dispute, and definitely one should be legal. This is only in addition to Dr. Kamal, how the IICRA rules align with the Sharia principle. Any comments?
I think if we take a comparative point of view, other arbitration institutions apply the so-called scrutiny process. They ask arbitrators to share the draft with the institution, and the institution will review the draft and scrutinize, but the scrutiny is limited to make sure that this award is enforceable. They would not open up and review the merits or the substance of the findings arrived at by the arbitrators. Except perhaps the ICC, if they find something during the scrutiny process, the court member of the ICC, court members in charge for reviewing the award, will say, perhaps the tribunal can think about this. Or we invite the arbitral tribunal to give consideration to that provision. Or maybe it would be good if the arbitral tribunal could elaborate on the reasoning here and make reference to the evidence in more detail. That's the type of comments we usually receive on drafts. To have a specialized committee or high advisory committee, how it is formed, how we choose the members of the advisory committee? Are they there all the time, or do they change?
Part of the team of IICRA is always advisory committee in order to support all of the requirements in all the cases, not only certain cases.
Right. Yeah, I think this is very consistent with the objective of IICRA as an Islamic arbitration institution, to make sure that the awards will not be contradicting Islamic Sharia. And I think it's a good idea, as Dr. Kamal said, to draw the attention of the arbitrators, but not to impose anything on them. This is very important, and obviously this is the case, just guidance and drawing your attention, perhaps here and there, a piece of Quran Kareem or Hadith, Nabi Sallallahu Alaihi Wasallam. That's very helpful. Regarding the qualifications and credentials of arbitrators to be appointed, I wonder how you make sure, if you have a sole arbitrator case, how you would make sure that this arbitrator is specialized in the area of dispute if the parties jointly nominate him. So if the parties jointly nominate me, myself, I'm not qualified to decide any scope disputes. I make it clear. but what if the parties jointly nominated me to come as sole arbitrator, and would the center say, no, we find that Ibrahim is not suitable, or what you do?
No, definitely. We have, at the end of the day, there is a contract of the arbitrator signed the contract with IICRA. Once he received the arbitration case, and on some of the provisions of this contract, he should comply with Sharia principles. Okay, this is one of the procedures that we apply to our rule. And in this case, the role of supervisory committee will be bigger and bigger, because if the arbitrator not enough prepared with this provision, so that we will send the report we'll send notification for the Sharia committee or the supervisory committee to take care about this award in order to review
Support.
to
give support to the.
Definitely, yeah.
Yeah. Okay.
And from practical wise, it doesn't find any Sharia committee, Sharia provisions, and some of our arbitrators in the security session will talk more about this point.
Right. Yeah, I think it's very interesting topic. That's why I'm a big fan of lively interactions. So I don't like the presentations. Anyway, yes, I think that's helpful to have this feature and support, if you like, from the center to an arbitrator who's not very much familiar with Islamic Sharia principles. Yes, these are my input on the topic. Yeah. One more question for me? Okay.
From our practical experience, as was discussed now, under IICRA rules, the arbitration proceeding, fast, effective, specialized arbitrators that's handling the arbitration cases, with a minimum duration, with an average duration, let's say, of 4 months and a half for arbitration proceeding to issue a final the award. And as Dr. Kamal said, the rule set specific and timeline, very specific timeline to control the arbitration timetable and arbitration proceeding. I think you have mentioned this doesn't exist in other arbitration. What do you think about
what other arbitration institutions say sometimes, like the Act, for instance, they say, okay, issue the award within 6 months from the date you receive the file. And you can extend for another 6 months if you think that the case requires more time. And if that's not enough, you can extend more by way of asking the court, the Dubai courts, to issue a decision of extension. That's an example of the ICC doesn't have such time limits. They give you time limits, but the court renews the time limit automatically. Cairo doesn't have any time limit. As I said, all arbitration institutions encourage arbitrators to be efficient, but no time limit per se. And even if with the time limit, with the existence of provision is limited to time limit, they give you flexibility to extend and give, because in my experience, it's not always, you have to maintain the balance between efficiency and due process. And you have to maintain the balance between efficiency and dealing in detail with the case before you as an arbitrator. You never know what this case will come up with. Sometimes we have massive construction cases, delay claims for, 100 delay event, asking for hundreds of millions of dollars, quantum reports, delay reports, technical reports, 20 factual witnesses, and in some cases, the hearing itself can take up to 3 weeks or 4 weeks. Sitting on a hearing, sitting time, day and night. That's the hearing that comes at the very end. During the proceedings, the exchange of witness experts, for example, reports. Sometimes we see the time intervals are 3 or 4 or 5 months, depending on the complexity of the case. So there is no, the conclusion is, there is no one size fits all, I believe. It depends on the size of the case, the complexity of the case. To be efficient is something that we encourage, of course. I assume the 4 months gives you also the...
This is average actually for all cases set up by IICRA right now, but I'm definitely agree with you regarding the efficiency. I thought in my speech, I'm talking about, yes, we have a short limit, but meanwhile, we give the parties equal opportunities to put their pleadings and defenses. Definitely, if we have witnesses, if we want more period or to extend the period, even in arbitration award period, if it's not 6 months, it's fixed by the rules, definitely correct, but the parties and the arbitral tribunal can extend. If they send a request for extension, definitely we can accept. But we are talking about
The average.
yeah, this is the average format.
If I will compare this, I don't have a statistics on the top of my mind, but I can. My guess would be in a typical commercial dispute in other arbitration institutions, the average would be between 1.5 years. That's typical, and perhaps 2 years or maybe more
So we're
would be.
taking account about the feature of arbitration. If you talk about the efficiency and the speed, definitely, if you go in more than 1 year, so go to the court better than the arbitration, taking into account the expenses.
Yes, if the time is needed and the 1 year is wisely used, then I think this will.
Is motivating the arbitrators to finalize in a short period. But Article 55 of the rules state clearly that the arbitral tribunal shall issue the final award within a maximum period of 6 months. So the arbitrators has 6 months, but the way, the practical way of the center and the mechanism there, they're proven in real life that the period was not used, the 6 months. They did not use it. Even they are allowed to use it. This is 55 number 1. Also in this, the tribunal shall have the power to extend such period for up to additional 6 months. So the tribunal has the power to extend. As per the law, you know the law 6, which enacted in 2018, the arbitration law, which now there are some amendments this year happened. This also empowered the tribunal with the 6 months and empowered them to extend 6 months. So the Article 55 are matching the UAE arbitration law number 6 on 2018, but at the same time motivating the parties and the arbitrator to finish it before, to apply what Dr. Rami said, that we need an effective way and using the time very wisely. Also, we go to what Mr. Ahmed said here, that some cases, especially in construction, where our expert there, the analysis, quantum, witnesses, so much witnesses we have to hear, the hearing time maybe 2 weeks. So sometimes we need to use this time, and it is allowed as per Article 55.
Yeah.
But if you don't use it, if you don't need it, don't use it. This is the idea. Thank you very much.
One more thing, Ahmed. It's like when the parties, sometimes they like tactic delays. Yes, so this is part of the strategy for one consultant over the other, for example. So this is taken into consideration. For example, when a lawyer comes to you, especially if it's a claimant asking for 2 months to bring a document. So this is not acceptable in case, but like there's a timeline, a specific timeline, like even we can give 1 week and we can extend another week. Yeah, and like even for witness, for everything, we have all like and other, but we manage as much as possible to have limited timeline to push on the consultants, the arbitrators, the center even supporting us and having like it's accelerated. So when you have a case with IICRA, you feel that you are under pressure, that there is timeline and you need to follow the timeline, otherwise you cannot miss anything. But if they ask for extension, we give extension. And what even help us, we have always like legal coordinator with the center. He is responsible about communication, he is responsible about. So this is part from administrative part is away from the arbitrators that help us in concentrating on more different issues, better like to be more efficient in the case.
Just to add, from my experience with the center, I'll tell you something about the administrative. I draft my, for example, procedural order. This center the same day, finalize it and send it to the parties. Do not take days with them. It's as if you are syndicate. You send it to the center immediately take action. Sometimes the last procedure order I make it at 4:30 afternoon. Before 5 o'clock, the procedure order was communicated to the party. Less than half an hour. You see.
I have a related question here. How the rules are dealing with the question of cost? Because usually legal cost or the awarding cost and against the losing party can also be used as a tool to control the delay tactics deployed by one of the parties. So you can, it's kind of sanction to the party who's deploying delaying tactics. Do you have something similar? The first question, arbitrators sitting under the IICRA rules have the power and jurisdiction to award legal representation cost or not?
Legal representation cost?
Legal fees.
As per the question, as you know, for the government, usually court, that there is a specific decision on this regard. The party should have power of attorney from the party from their parties in order to ask or in order to union the request of the cost of.
Yeah, I know the case you're talking about. That's
Yes.
No, I'm asking because the situation, the position was in the old IAC rules, 2007. Arbitration tribunals had the power and jurisdiction to decide arbitration cost, but not legal fees. And then when an arbitrator decided the legal representation fees by one of the parties, this case was not nullified by the Dubai court, and the Dubai Court of Cassation, from your reference, it's case number 282 of 2012, that's a landmark case. And then the court stated that for the tribunal to have the power and jurisdiction to award legal representation fees, there must be an agreement to empower the tribunal to do that. Then an arbitration tribunal later issued an arbitration award with the legal fees, and there was an agreement, but this agreement was signed by the lawyers. That's the case you mentioned. That's case number 990 of 2019. In that case, the lawyers didn't have sufficient power of attorney. They didn't have special power of attorney to agree, because the court considered that empowering the arbitrator to extend their jurisdiction and decide legal representation fees requires a special power of attorney, because it's amending the arbitration agreement. So what happened in the new DIAC rules in 2022, they changed the rules and they stated expressly that arbitration tribunals sitting under the DIAC rules are empowered to award legal representation fees. So this was sorted out. That's why my question. And this is a very important feature, by the way. I think it's very important sanction tool in the hand of arbitrators to deal with the parties' delay tactics in some circumstances. Sorry if I took
This is just elaboration. This is very important issue raised by Mr. Ahmad. But I just want to read to you, just 2 minutes, the Article 62, cost of arbitration and fundings. The arbitration costs, including the arbitrators' remuneration, administrative fees, experts' remuneration, and other expenses, shall be determined in accordance with the provision of the regulation of arbitration and reconciliation expenses, the next one. So there are here award expenses. Expenses must cover legal costs.
I disagree.
Yes.
I'm a big fan of disagree.
Yes. I understand your point, and I understand. I was the party who faced this problem, and in my last award, it was an ad hoc arbitration, big ad hoc arbitration, 2.3 billion dirhams. So the expenses are
I think we
We'll see
should
the time.
end this
We have
session. We
questions.
still have one question, but I will end this session because we need to give like 5 minutes for the audience if they have any question.
I do actually have a question, please. So from my understanding is that when we choose an institution, we're choosing procedural law. And when we're choosing governing law, that is substantive law. And I feel like if I, as a council, for instance, drafting the agreement and I choose IICRA, and it's because the matter at hand is, for instance, sukuk, mudaraba, murabaha, and I want people to be on the tribunal to understand this. But I do not want their opinion that contradicts the governing law. And I feel like this may be blurred.
How you need their opinion?
I feel like, for instance, because like Sharia law is different from one country to another, and it's different from one school to another. And say, for instance, I choose to the governing law to be the UAE, right? And so the arbitral tribunal is going to have to follow the substantive law of the UAE, right? But what if that contradicts with their view on what a sukuk or mudaraba or murabaha situation must be, the way in which it must be resolved? What
You mean
happens?
contradicting the views of the tribunal or the views of the advisory committee?
The tribunal, because the tribunal then it will go to the advisory committee who may even have an opinion that also contradicts the governing law.
The tribunal in general has an upper hand in deciding how to apply the law.
The governing law.
The government law, they will have to apply the law, and if you choose the UAE as a government law, any of the treaties should apply the law.
And is
But
there,
the feature of the center is to review the draft, to make sure that there is nothing in this law contradicting Islamic Sharia. That's my understanding.
It's correct, yes.
Yes, it's correct. And plus, whenever like in any application procedure, we have lots of reference to a UP standard that like has more than 59 standards that deal with each and every specific. For example, for murabaha, there is one standard. For musharaka, there is another standard. For each and every subject related to Islamic finance or transaction, it's a full, comprehensive and detailed standard that give the full line with in relation to any specific matter. Plus, even the UAE's commercial transaction law was amended recently, and there is specific even provision related to some Islamic transactions, like murabaha, mudaraba, many others. So all this together here will be the tribunal work and the arbitrator work to make sure that it's aligned with all of this. So even in one of the awards that we issued recently, we have relied on MPP, we have relied on the commercial transaction, definitely on the some UAE precedents, court precedents. So all together, you mix them together to make sure that you apply properly. Any other questions?
We have two questions.
Okay, sorry. Good afternoon. I have actually two questions, if I may. I think it's all right. Thank you. The first question is to the panel and practitioners around the table. I'd like to know if you have come across any challenge in a non-Islamic jurisdiction of the enforcement of the law under the IICRA, especially like in a context, for example, where it may be argued in such non-Islamic jurisdiction that a decision made by the tribunal may contradict or may not contradict public orders in such jurisdiction. For example, it is a reference, it would be under Sharia law, but it is a reference to hadith, which may not be recognized or may not be understood in such non-Islamic jurisdiction. That's the first question. The second question is to the secretary of the center itself. When we are structuring Sharia compliant facilities, for example, I came across Sukuk and Murabaha, we need to have the approval of a Sharia compliant facility. It's a no-go, it's mandatory. So in the case of this arbitration award, why the higher committee adjusts the supervisory role and not just an advisory role and not the supervisory role? when there is an overriding requirement for the award to be Sharia compliant. So why only an advisory, why the higher committee is just giving an advisory decision or guideline and not mandatory? Because then there may be a risk that the award is not aligned or fully compliant with Sharia.
Okay, thank you for your questions. Yes, we have two questions. The first question which you talked about is that if we are now here outside, we are having an award and to be enforced in another country. The other, and this award has something inside against the public policy of the other country. This is a case for it is under Sharia law or not under Sharia law. If something is against the public policy in the other country, the judge will not apply. And it is related to the merit. The merit could not be opened. But if it is against the public policy, they will not enforce the award. So it is a matter of public policy, not the public of Sharia.
Yeah, but I was referring to a non-specifically, yeah, I understand.
Yeah.
Definitely understand that it applies to any law, right, when we come to enforcement of executive.
Yeah.
But I was referring, did you come across any challenges in non-Islamic jurisdictions with regard to an arbitration, the IICRA, for example, which is Sharia compliant? Specifically, sir, you refer to hadith, right? You will not be understood or may not be recognized in a foreign jurisdiction. Just to understand if there has been any cases that you or practitioners around here have come across such challenges.
Let me just give some comment and give it to comment. Your question here is split into two things. If the other jurisdictions, they don't depend on this hadith or they don't consider it correct, for example, in their view, okay? This is something related to merit. Now we are to talk about public policy and the enforcement. I will leave it to Dr.
Actually, I have a comment, sorry, Dr. Rami, before to interrupt. The presumption here is that you have an award and you want to enforce it in a foreign country, and this will go under the New York Convention, 1985, 58. Okay. And one of the grounds to refuse enforcement is that the award is against the public policy in the state. Your question, have we come across? I came across the other way around many times. So it's an award issued somewhere else and being enforced in a country that foreign award is breaching public policy from an Islamic point of view. Such as, for instance, in Egypt, the maximum interest that can be agreed between the parties is 7%. So there was an award issued in London, awarded 8.5%, and when they wanted to enforce it, the court in Egypt reduced the interest, did not refuse, but reduced the awarded interest from 8.5 to 7% to make sure that it's compliant with the public policy in the country. The scenario, the other way around, is not imagined. I cannot imagine it. You know why? Because I don't think any country will say this award is relying upon hadith. Yeah, okay, what's the point? You don't need to be recognizing the hadith or Quran. It's not about recognition. The question and the threshold is this rule violating any public order in your country or not? So I don't think any hadith or any Quran can be violating. The non-recognition is something. Yes, any foreign country can say we don't recognize this. That's fine. But equally, we don't recognize Vietnamese law here in Dubai. But if we have an award issued under Vietnamese law, we will enforce it. No. Again, Vietnamese, because I'm keeping using the example of Vietnamese law many times during the arbitration week. But yeah, but there was a discussion this morning with Dr. Rami regarding what if the award here says there's no interest, zero interest, we will not award interest, and obviously this is because interest is against Islamic Sharia. And a court in, let's say, London or Singapore or somewhere else says, oh no, we hear award interest, this is against our public policy. I don't believe this is the case. The court there will say, okay, if the parties agreed, we respect party autonomy. That's a mutual agreement not to apply interest. That's fine, it's not public policy. But maybe the court will apply interest after the award, not before the award. From the time the award has established a debt and should be paid, so they can, it's an interest by statute. That's not according to the law. Do you agree with me?
Yes. Actually, yeah, so in order to save the time, we need to.
I'm very talkative.
As we discussed in the morning, brother, we talk regarding this issue. Actually, let us to talk from practical wise, we doesn't have any challenge for the enforcement at all. In many jurisdictions, we enforce it in Morocco, in Saudi Arabia, in UK, in different jurisdictions, we doesn't have any challenges on the enforcement. Since the arbitrator is coming to the IICRA in order to settle this dispute, and they know already that the arbitrator they will not conflict with Sharia principles. This is the regarding supervisory committee. Actually, when we make it mandatory, we conflict with the.
I think
this would be a reason. This would be a reason to refuse. So this would be a reason to refuse enforcement. By the way.
No, because
the tribunal has the
tribunal. Yeah, the tribunal has already one Sharia specialized, and you need to keep the tribunal as an independent tribunal to make sure that the advisory board doesn't interfere in the work of the tribunal. So this is
and one of the principles of arbitration, the arbitrator tribunal has the competent is competent.
Yes, yes.
So you cannot take this right from the arbitrator tribunal. Taking into account what Dr. Susan said, we will take all the procedures in order to give the plan or give the way for the arbitrator tribunal to we guide her, the arbitrator tribunal to issue the arbitral award according to the So we cannot give it as a mandatory, but we can give as a supervisory opinion or report in order to take care of the issues which is conflict with Sharia, conflict with Sharia, as case the similarity. Maybe our distinguished speakers in second session will talk more about this issue, and we will talk more about the Sharia scholarity and the Islamic origin of Islamic finance in general.
I think we exceeded our time.
Yeah.
Thank you very much.
Thanks, everybody. Thanks for the audience.
Thank you very much, Dr. Suzanne, Mr. Ahmed, and Dr. Kamal for the insightful and interactive discussion. At this point, we'll have a 10-minute break for coffee and networking, and then we'll start our second session. So you can proceed at the back part to grab some refreshments.